got wonderful people here. We've got on Zoom as well. We've got Michael Doyle and Ayten Gündogdu on Zoom who are going to intervene. Of course, Seyla Benhabib will be mastering the conversation, moderating the conversation. We've got Frédéric Mégret. We have Susanna Mancini. And we also have with us, fortunately, Dean Gillian Lester, who was very supportive of this project. And so I think I'll turn it over to her first before Gillian Lester turns it over to Seyla Benhabib.
Yeah, it's really, thank you, Barnard. It's really an honor to be able to help kick off today's convening to celebrate the release of lawless zones, rightless subjects, migration, asylum, and shifting borders. Thank you to everybody who's here today, whether in person or online. Obviously your presence underlines the importance of the issues. I'm amplifying some of Bernard's themes, and it allows me to extend into a post-dean period gratitude for something that began while I was still dean and that I cared about very much, this project. When Seyla approached me about its conception, sparked by conversations with Ayelet, both the convenings they envisioned as well as the collection they ultimately hoped to create, I immediately understood the importance of what they were trying to do. And the resulting book that we're celebrating today, with contributions from 18 really fabulous people from, including, of course, our co-editors, Seyla and Ayelet, really represents a model of interdisciplinarity. So the best of what we can bring together between political science and law, as well as US, Canada, Europe, and really also a range of methodological approaches and perspectives. So it's a great convergence of many strengths to the critically important project, as Barnard pointed out, of looking at migration, statelessness, and the plight of asylum seekers, one of the most pressing issues of our time. Many reasons for it to be so important and of rising importance: global capital flows, climate migration, geopolitical conflict and violence, stark global inequality, and it's having foundational impacts on previously bedrock understandings of the boundaries of the state and the definitional role of territoriality. And one of the things that I think is striking is how even in the time since the convening and the drafting of the chapters that became this book that just came out, the issue has grown even more in urgency. Even in that brief time, as populist national movements driven by anti-immigrant and racialized hostility have become critical vectors of influence in global affairs and in the rise of fear-mongering ethno-nationalist political regimes in both the United States and abroad. And in sum, this work just couldn't be more important. One more thing I'll say before I sit down. The publication of a book is always a cause for, and the effort behind it is always a cause for celebration, but it's an even greater cause for celebration when it reflects, as this does, a collective endeavor among scholars in conversation with one another. It's really the best way to build new knowledge and push the boundaries of how we interpret the world and what we think we know. Given all this, I have no doubt that this afternoon's discussion will be stimulating and it'll add further depth to our understanding of this complex topic. Once again, thanks everybody, and thanks so much for inviting me to speak. Turn it over to the panel.
I think this is on, is it? Well, thank you very much. Our tireless 15th ex-dean of Columbia Law School. Thank you, Gillian, and thank you, Barnard, for everything that you do in creating an intellectual space of many different voices and orientations. And thank you, Ricardo and Jasmine, for all their work in putting this together. To my left is Ayelet Shachar, my old friend and co-editor, who has the Harney Chair in Multiculturalism, Migration at the University of Toronto. She's a distinguished international scholar and also distinguished professor or visiting professor of comparative constitutional law at Berkeley. To my right is Frédéric Mégret from the University of Montreal, and of many, many visits and claims, but a real pleasure to have him visit with us as James Carpentier, visiting professor at Columbia Law School. And to farther right is Professor Susanna Mancini from the University of Bologna, who has become a dear colleague with whom I've done the Columbia Cardozo Transnational Law Seminar, and I always learned from her about European law, and I hope our cooperation will continue for many years. Now, as we write in the preface, this book started during the months of the COVID-19 pandemic. We forget what we have been through. And Ayelet and I were having a conversation, we have been talking to each other for over 25 years over issues concerning multiculturalism, gender rights, and then we both worked on citizenship rights and their transformation, and of course, the question of migration. Now, in 2020, I published a journal article called The End of the 1951 Refugee Convention, Dilemmas of Sovereignty, Territoriality, and Human Rights. It might have been a bit full of chutzpah because I'm not trained as a professional international lawyer for me to put a question mark next to the Refugee Convention, but I was raising a question and a puzzle. And this was 2020. And that same year, I read Ayelet's book, The Shifting Border Legal Cartographies of Migration and Mobility. And this was one of these moments, again, of intellectual convergence, where you realize that, you have been asking similar questions, but of course, Ayelet is trained as a constitutional scholar of, comparative constitutional scholar. And it seemed to us that what was happening was that the congruence that we take for granted in this misnomer concept of the Westphalian state is the overlap, in some sense, or the congruence of territoriality, jurisdiction, and rights. And we were both beginning to see phenomena where this was coming apart, or use the French word décalage. They were no longer cohering. And of course, there is the famous case that's very well known to refugee and migration scholars of the so-called excising of the territory, Australia, Cocos Islands, that were simply a state withdraws its jurisdiction from that territory. And so this question of excision of territory has been occurring, but there is also the very puzzling case, for example, in the border between Europe and Africa, Spain and Morocco, Melilla and Ceuta. If you have ever looked at, the topography of this, it's a remarkable situation where there are 4 walls. And if refugees are on one side of the wall, they seem to be in the European Union, but really not. Spain says this is not European territory. Morocco says, but yes, it is. And Ayten Gündogdu's piece in our volume and a couple of other pieces deal with this absurdity of not being able to really define what exactly is a territory and who bears responsibility, because the consequence of this is that if you are on the soil of the European Union, the European Convention of Human Rights holds, and you have certain rights. But if you are not in no man's quote unquote territory, then you are a rightless subject, right? And so this is a phenomenon that Matthew Gibney had called 1,000 little Guantanamos, but we know in the case of Guantanamo, and Barnard has worked on this, that the relationship of American constitutional and statutory law to Guantanamo and to the few prisoners who still remain there is quite complicated. But what the phrase 1,000 little Guantanamo signifies is precisely this attempt on the part of states to create empty or puzzling spaces which are vacated by the law or where they want to push the law back, and hence lawless zones. And there are, I'll just name one more example, and that is the famous agreement between Turkey and the European Union about Turkey making sure that refugees coming from the larger Middle East, Iraq, Iran, Syria, Afghanistan, and Africa also do not enter the European territory, that they are caught before they reach the Greek islands, or in some cases now even the Bulgarian border is becoming active. But so the agreement was that the European Union was going to give Turkey a certain amount of subvention, but the subvention was going to come at the time. There was an earlier, I will know the details, the UN agreement that the refugee camps would be supervised. In the meantime, the refugee camps have come under the jurisdiction of the Turkish government. There is no international supervision. So what is the status of this agreement? So we were struck and at times dumbfounded by these developments. And that's when we began the first Zoom conference in 2001. And then our thanks now to our colleagues in Frankfurt, but first thanks to Ayelet, who has used the Leibniz research funds that she has received for the Transformations of Citizenship project, to gather 20 of us together in Frankfurt, and in Frankfurt, the Normative Orders project with Rainer Forst. Again, many thanks to them for really supporting us all the way. And I wish to mention also that something that European universities do, but very few American universities have had the means. This book is open access, which is wonderful for students. You just go on the Cambridge University website and you can download it. And again, thanks to Frankfurt Normative Orders that we can have this. And last but not least, somebody without whom this would not have been possible, Eva Maria Schäferle. Eva, I hope you're there.
I see her.
I hope you're there. And so thank you very much. And one more sales pitch, and then it has an incredible bibliography. We prepared the bibliography for teaching purposes, and I'm going to be assigning this book for teaching purposes next year. We worked very hard to collect online sources, international law documents, and other bibliographic information. Now, without further ado, I'll give the word to Ayelet, but I forgot to introduce our colleagues on Zoom. After Ayelet, Michael Doyle, University Professor at Columbia University, will be speaking. And after Michael, we have Ayten Gündogdu, Associate Professor at Barnard. And then we have our distinguished colleague, Frédéric Mégret. And Susanna Mancini will make the concluding remarks and lead us into the discussion. So,
all right. Good afternoon, everyone. Thank you so much. You're the brave souls, right? On a Friday afternoon, it was a beautiful day, and you chose to spend your time with us. So we are deeply, deeply grateful for that. I also want to thank, of course, Dean Lester. Thank you so much for your support. It has been really amazing. And it was true that I think you had a real good grasp of this project from day one. And I'll say a little bit more about the project and what brought myself and Seyla Benhabib together. But of course, also I want to thank Barnard Harcourt for hosting us for this event and again for your support. And of course, people who are online, hello, we're very, very delighted to have you. We have two contributors. I see Svenja as well and Eva Maria, so really lovely to have you with us. But just before I turn to the materials themselves, I do, my deepest gratitude, of course, is to Seyla. She has been very modest in the way that she presented this, but this project was a meeting of the minds, which rarely occurs. And we were just extraordinarily fortunate. We were both thinking about the same set of issues from different angles. Of course, Seyla, from her critical theory perspective, I came from it more from the legal dimension. And we were both worried about the legal implications, the democratic implications, the normative implications, the global justice implications. And it was just such a rare moment because we really were thinking about this independently. As it happened, I do believe that the fact that the pandemic was actually highly in effect, right? This was the time when we were all locked in. So we had a couple of Zoom meetings and it was just so incredible to us. We knew that we had to do more work on this. We wanted to bring in additional voices. And it was just one of those moments where you really appreciate being in academia in the deepest possible way. When we have this freedom, the time, we actually had a good amount of time. We started early on with the Zoom meeting, which we brought a lot of people in. Then I was very lucky that my Leibniz Prize funds allowed us actually to come to Frankfurt, and Frédéric, you were there with us, and several other people, colleagues who were with us. And then based on that, we asked people to contribute. We are both very nice people, but super tough editors. So everything was online. We were amazing. This book was, done like with marching orders, but we also worked very extensively with our various contributors. And I think you'll see that if you get to read the book. Each piece really has its own voice, but they all speak together. It's like an orchestra together. It's just much more beautiful. So we are really incredibly lucky to have this opportunity to share this with you. But really, my deepest thanks, Seyla, my sister in arm. So we are just very, very lucky to have had this opportunity to work together. And of course, Seyla needs no introduction in this room. Now, my modest task, and Seyla was actually giving me the marching orders for this. And initially I was told 8 minutes to present a book of 362 pages with 16 chapters and our extensive introduction. Now, there is no chance I can give you the full vision of what happened in this book. So instead, what I want to do is really give you a bit of a sense of what the project is about. And then hopefully you'll have and it's also online, so you'll just have an opportunity to download the chapters, or at least my comments are based specifically on the introduction, and you'll hear about a few of the chapters later on in the discussion. So first of all, before we begin, I just want each and every one of you here just to take a moment and just to think, what is the first image that comes to your mind when we talk, or when I would say the word border? What comes to mind as a visual image? We're not going to have time to go around the room, but I can tell you I've asked different rooms literally around the globe with policymakers, with students, with activists, various, of course, with academics, various audiences. I think to a great extent, the most prevalent image that we have when we think about the border, just again, the intuitive first image that would come to mind is something like a border wall. Right? You might think about the Mexico-US border, a barbed wire. You might think about a fortified barrier. Or for some of you, it might just be a line on the map, right? Thinking about a division between where one country ends and the next country begins. It's just so imprinted in our mind as a visible marker, usually a visible marker at the edge of a given country's frontier. And because it is so familiar to us, I'll just call it the static border or the familiar Westphalian border. And of course, to some extent, those of you who have worked early on, and I know some people in the room have done this for sure, In the late 1990s, you might recall that there was an alternative image of after the fall of the Berlin Wall, when people thought that we would have a totally different era, right? A much more optimistic era of human rights across borders, of focusing on persons rather than citizens. And that was a notion of a disappearing border, but a disappearing border in a very, very progressive manner, in a manner that would permit greater freedom to individuals, and borders would still be relevant, but would not necessarily play the role that they have played previously and they play today as barriers to mobility, as to some extent containers of power that leave people who are trying to cross the border from a poorer country, from a less stable country to a richer one, in a very unfavorable position. So our task in this particular book, or what we gave ourselves as the task that we took in this book, is to really challenge this very canonical view of borders. And not only to challenge the canonical view of borders, but also to try and think about the underlying assumption, of course, which is sovereignty, which, as we typically understand it, is correlated very clearly with a clearly demarcated territory, with jurisdiction. That is a given government that has jurisdiction over that territory and can exercise a scope of legitimate authority. And that typically includes, in our current understanding of the typical understanding, the static Westphalian understanding, it also typically includes some control over borders, over mobility, over membership boundaries. So what we tried to do through our introduction, and later on the various chapter writers, I'm looking at you through the website, through the Zoom connection that we have here, is to really try and see, first of all, trace how these basically legal assumptions are under increased strain. That's just a descriptive element, just to explain that despite the fact that we're still working with a particular model, states have been far more entrepreneurial and creative in terms of how they regulate mobility and migration and movement. So partly just to trace that increased strain of the current traditional model. But also we were trying to explore, and here we were really interdisciplinary, and thank you again, Gillian, for mentioning that, because we were using legal perspectives, historical, philosophical, ethical, discursive, postcolonial lens. We really tried to bring a very rich set of lenses or perspectives to try and understand, first of all, how this destabilization of the traditional model is occurring, but also what are the implications? That is, what happens when these deep common grounds upon which the law stands, so to speak, are no longer stable. And again, it's not that they're no longer stable in that 1990s happy story of greater freedom. It's really the reverse, or the pattern that we're seeing. And again, if we just want to have our punchline in terms of how we put it in the introduction, we said that we seek to identify how the territoriality of the modern state, arguably the most stable and unquestionable element undergirding the current international system, how this particular aspect, territoriality, has been written and dramatically reimagined. And it was dramatically reimagined, and this is important given that we are under the auspices of Columbia Law School, to a great extent through the words of law, that is, legal transformations that have caused this change. Also, we really emphasize the actions of migrants, and I think, Fred, your chapter really speaks to that. So we were very mindful of the agency of migrants themselves and trying to, how they would see the border, how they would challenge these understandings. And also, we were quite worried about the tremendous discretionary authority that these changes actually grant governments. And I don't want to say grant governments. I actually want to say governments have proactively given themselves license to redraw the border. And through that, they have gained tremendous power in the sense of regulating precisely the elements that we're thinking about: borders, migration, and membership control. Oh, of course, you should have told me earlier. All right, so do I have to repeat everything, or you heard a little? Hopefully you have a little bit. The gist of the argument is we're trying to re-explore the implications of the transformation of territoriality. And we said this is a central element because it's so central to sovereignty and it's so central to our understanding of the law, and also to rights protections that attach to being present on a particular territory. And I don't have to remind you, this was true when we wrote the book. This is definitely even more pressing now, that across the globe, no other issue, and here it's a quote from Bimash Ghosh, no other issue has galvanized tension and anxiety quite like, and this is a quote, the fear, both real and perceived, of huge waves of future immigration from poor and weak states. And this, as we know, is exacerbated now with the anti-immigrant sentiment, with the far right, with the populist nationalists, the democratic and constitutional backsliding. So our concern was to try and understand how these kinds of changes, how specifically borders, and the movement of people across them have become so controversial, bitterly contested. And again, also we try to end the book with some optimism, how we might democratize these shifting borders, how we might rethink some possibilities for change, despite the quite grim and depressing reality that we are tracking in the book. Now, depending on how much time you still want me to talk, I'll decide how deeply to go to the examples. 5 minutes? I agree. I agree. So what I'll do then, I just want to give you 2 examples, which will make this discussion a little bit more abstract. So I actually want to start with a current example and build on something that Seyla already mentioned, the excision, the invention of lawyers, government lawyers in Australia, which suggested that if you land initially at the northern part of Australia, you had to come, if you came by boat without authorization and physically arrived to the territory of Australia, according to any traditional interpretation of the right of asylum, by presenting yourself, attaching your body to the territory at that moment, the universal right to asylum becomes attached to a particular country, in this particular example, Australia. And it's a big debate among human rights lawyers. Why is this the given interpretation? But let's take it as given. You have to attach a body, a person has to arrive to a territory or to the border or the territorial waters for the right to asylum to materialize. Australia was very worried about precisely this fear that I have mentioned to you. It became a very contested political issue in that country. And to address it, as I said, they came up with a legal fiction. They said, even if you physically arrive to the territory of Australia through legislation, this is all visible, it's not invisible, this is not behind the scene kind of action, through legislation which changed their immigration law, Australia declared parts of its territory to be excised, to no longer be Australia if you're coming in as a migrant or as an asylum seeker seeking protection. It's a total invention, and in some way, from a state's perspective, brilliant, because now they had a way to say, you arrived, you're physically here, we're still totally committed to our human rights obligations. Australia has not stepped away from the 1951 Refugee Convention. We are still, Australia will say, deeply committed. If you arrive, even if you fly in, because we then check your passport, we know who you are. But if you're uninvited, we will not allow you to actually seek asylum. Now, of course, they had a problem because people physically, we are embodied. So individuals actually were in the territory, but they couldn't seek asylum there. So then they came up with their second invention, which was the invention of transferring people offshore, outsourcing, offloading, the different terms that you will find in the literature referring to the same action. Papua New Guinea, Nauru, really far away islands that became sort of prison islands for those individuals who were waiting for the asylum process, which could take 3 to 5 years. Something fascinating about that, a very high percentage of the individuals who were actually offshored had gained asylum. That is, they gained refugee status, a very high percentage, in some years over 80%. So these were totally legitimate asylum seekers. Now, Australia, as a last move, and then I'll connect it to the US, also said, coming to Australia without permission is like a black hole. You can never, ever come back to our territory, because they wanted to deter mobility. So even if Australia recognized your claim as an asylum seeker, and let's assume you actually received your status as a refugee, Australia will invite you then either to stay in Papua New Guinea or Nauru, or as an alternative, they would resettle you in a third country. So they're not ignoring their obligations. They're just saying, not in our territory. So this is, for us, an extreme example of how territoriality is being reimagined. What's the relationship to human rights? What's the relationship to migrants? And recall, we do have a universal right to seek asylum. It's an unbounded in that sense. Nevertheless, it is here limited through these legal games, through these reimaginations of territoriality, through the words of law and its interaction, of course, with the action of individuals. I mentioned this because I also mentioned this yesterday in the colloquium that we had about citizenship. But I think that one way to think about the current executive order in the United States trying to restrict birthright citizenship is exactly the same logic. That is, the territory still remains the United States. Individuals will be in the country. Let's assume it actually, the courts in some modified variation permit this. If they block it, wonderful. But let's assume it's permissible, or let's assume a narrow version thereof is permitted. it might mean that you would have children who would be born on the territory, born un-American, right? Because they would be born here. They could not gain citizenship, but they would physically be here. So to some extent, I would see that this legal imagination, the executive imagination here is saying, the territory is just for them, it's excised. That is the idea that automatically there's a connection between territory and a right to membership, which in the US context is actually constitutionally protected. So this is the highest kind of, this is the 14th Amendment, the citizenship clause, it's the first sentence. I think that this would be under the jurisdiction thereof. I think this is the kind of game that they're playing, and it's a very, very dangerous game. So just to share that with you, why this is real, why once a legal technique is introduced, it could travel the world, and we have seen countries borrow from one another. And two last points that I will make. All of the countries, see, Seyla, you told me 7 minutes, then you told me 15 minutes. Oh, right, I'm going to wrap up in a minute. But I do want to say one thing, that the reason why this is important, and the countries that we have studied, these are countries that do not suggest, they're countries that are committed to human rights, at least at the rhetorical level. To some extent, we want to say that gives some space for pushing back because of that gap between the rhetoric and the action. Some people would say it's just a double standard, but I think we want to suggest that it actually permits some room if we're trying to think about either democratizing these borders, challenging these borders, taking migrants' action seriously, finding a way to actually give meaning to these human rights obligations that countries have taken, despite this reconceptualization that they have done. We want to suggest that there is still room for some resistance. And indeed, really, the puzzle that we are seeking to address in this volume, and then I will close on that, is really to try and understand the remarkable malleability and versatility of the categories of asylum, protection, immigration, and as well as, this is really our alarming call here, the collateral disillusion of human rights and protections afforded to those on the move through these precise legal techniques. And we really have been trying with our authors to think about how to address these constellations or these new relations of power and authority, and by really exploring how migrants and other activists, could be people within the country who are trying to protect these human rights, could really think about new normative responsibilities, political ways of expressing voice, as well as just trying to resist here the brute exercise, in some cases, brute exercise of state power in these lawless zones where rightless people increasingly find themselves in a world of rapidly shifting borders and now shutting down opportunities for asylum. So thank you so much. Looking forward to our discussion.
Okay, thank you. We have
Hello. I'm sorry, I couldn't hear. We were disconnected for a little bit, but can you hear me now? And Ayelet and Seyla, did you ask me to start? I'm sorry, but I can't hear anything from the other room. Uh, I can't hear anything from your side, so I'm not sure whether I'm just jumping in and taking over or responding to your request that I should speak. I think that I see Eva nodding that you're asking me to speak. So I'm assuming that you can hear me, even if I can't hear you. So I'm gonna,
yes, please go ahead. Please go ahead.
now I can hear you.
Okay,
Okay.
terrific.
I'm just delighted to be here. I want to start, of course, by thanking Ayelet and Seyla for organizing not just this meeting, but the wonderful meeting that we had in Frankfurt more than a year ago. They've identified incredibly important themes of lawless zones and rightless subjects, and I am honored to have been asked to join them. My particular theme is forced migrants, human rights, and climate refugees. Quite literally, we're talking about, in this topic, the dissolving, almost literally, of territoriality, as some islands and island states have gone into the water, leaving, and here the pun continues, human beings literally at sea with confusing rights, strong claims, and very little support. In my 10 minutes, which I'm going to take seriously, I want to cover 5 topics at a minute to 2 minutes each. The first is just to remind you of the significance of climate change, particularly with regard to small island states. Talk about 2 protection regimes, the Refugee Convention and the Model International Mobility Convention, neither of which provide adequate redress and rights protection for persons newly vulnerable to this form of climate change. Talk about an important case, the Teotihuacan case before the Human Rights Committee, which attempts to set standards, some of the limitations of Teotihuacan, and then I want to conclude by an argument for having a special treaty for climate refugees. But first, climate concerns with regard to the dangers faced by small island states. 150 million people are currently living on land that is projected to be below the high tide line in 2050. 8 islands in the Pacific have already been submerged by the rise in sea levels, and 40 more are expected to be underwater by 2100. Today, according to recent studies, 1% of the Earth is barely livable hot zone. By 2070, 19% could be. In extreme scenarios, 30 million migrants could surge from countries that are desperate, including from Central America, and in this model to the US in the next 30 years. We have 2 major protection regimes dealing with persons in emergency situations trying to cross borders. One, of course, is the Refugee Convention of 1951, 1967. It has a key element that you have to be able to show persecution, which implies intent and targeting. And the grounds for protection and asylum are race, religion, nationality, social group, or political opinion. And they're not poverty, not desertification, and not inundation. 40 migration scholars, here's a second protection regime, got together beginning in 2016. They were migration, refugee scholars, political scientists, international lawyers, retired officials. And they got together and proposed a model international migration mobility convention. And they took the radical step of broadening the 1951 standards to include protections for forced migrants. And a forced migrant is every person who, owing to a threat of serious harm, consisting of a threat to an individual's physical survival, which is external to her or him, have a claim on asylum. And we listed as potential drivers of this need to move: indiscriminate violence, severe international or internal armed conflict, environmental disaster, enduring food insecurity, acute climate change, or events seriously disturbing public order. We thus broaden the grounds for a claim to asylum beyond the 51 Convention, but limited to an individual's physical survival. Both of these standards have limitations, and they were revealed in an important case brought by Johan Teotihuacan, a national of Kiribati in the South Pacific. In 2013, he applied for asylum in New Zealand on the grounds of climate change, but was rejected as a climate change refugee by New Zealand and then United Nations Human Rights Committee, to which he appealed. The grounds were straightforward, given the 51 Convention. He was not persecuted on any one of the 5 protected grounds of race, religion, nationality, social group, or political opinion that would have established his credentials as a refugee under the 1951-1967 Convention. The Human Rights Committee then examined the case after he had been rejected by New Zealand, and in 2020 issued their view. The committee affirmed that he could not make claims as a refugee. He didn't fit the 51 Convention. But in a very important statement, went further and said, and I quote, "The committee is of the view that without robust national and international efforts, the effects of climate change in receiving states may expose individuals to a violation of their rights under Article 6 or 7 of the Covenant, thereby triggering the non-refoulement, that is, the right not to be expelled, obligations of sending states. Furthermore," they continued, "given that the risk of an entire country becoming submerged underwater is such an extreme risk, the conditions of life in such a country may become incompatible with the right to life with dignity before the risk is realized." That was a very important statement. And they also went on, I think in interesting ways, while they were rejecting Teodo's claim to refugee-based asylum, to establish 6 standards under which Teodo, in their view, would have qualified for asylum. He would have qualified if, and I quote, "he had been in any land dispute in the past or faced a real chance of being physically harmed in such a dispute, if he would have been unable to find land to provide accommodation for himself and his family, if he had been unable to grow food or access potable water, if he had faced a life-threatening environmental conditions, such as if the entire island was flooding and no land was available, if his situation was materially different from that of every other resident of Kiribati, or 6, the government of Kiribati had failed to take programmatic steps, I quote, to provide for the basic necessities of life in order to meet its positive obligation to fulfill the author's right to life." They then went on to agree that Kiribati, and here this is a little shocking, faced likely inundation in 10 to 15 years. But the intervening wild optimism, 10 to 15 years, allow for intervening acts by the Republic of Kiribati with the assistance of the international community to take affirmative measures to protect and, where necessary, relocate its population. The wild optimism of that conclusion is that this was a conclusion that was drawn almost 10 years ago. So it was a very important, a landmark decision. It's one that scholars in the field of refugee rights, Professor McAdam, most eminent among them, have focused work on illuminating. We can see, good as that decision was, or at least interesting as the decision was, it had a number of limitations. The first, as was pointed out in the dissents by Vasilka Sancin, that's Sancin, and Duncan Lackey Muza, that's Muhumuza, note that it wasn't just Teodo's interest at stake, but that his family had bad health issues, with one of his children suffering from a serious case of blood poisoning, causing boils all over the body. And that, of course, triggers the Convention on the Rights of the Child. Number 2, Article 7 also includes dignity standards in the covenant. They prohibit degrading treatment beyond the imminent threats to life referenced in Article 6. And as later elaborated in another case, the Torres Islands case, which was not an asylum case, these were the Torres Islands, part of Australia, the Human Rights Committee nevertheless went on to define fundamental rights to family life and indigenous culture that could be threatened by severe climate or even slow onset climate change that made the practice of their culture. Here it was palm oil and the cultivation of palm oil as being part of the culture that could be threatened in a way that triggered rights. And lastly, another limitation of the Teodo decision is the standard of likely harm. The committee's decision could be justified in that Teotihuaca did not face imminent harm as they assessed it. However, the standards actually invoked by Article 6 and 7 refer to, I quote, an imminent or likely risk of arbitrary deprivation. So what does likely mean? I found an interesting discussion of this in another case, the case of A before the appeals court, the administrative court of Bordeaux in France, again in 2020. Mr. A, if he would be deported back to Bangladesh, according to the court, Bangladesh being his country of origin, would face a worsening of his respiratory diseases because of atmospheric pollution that could not be well treated by the hospitals in Bangladesh. And that provided a grounds for his claim of asylum in France. Here's where I wrap up. There is a case for having a special treaty on climate refugees. Obviously, it doesn't fit the 51 Convention. On the other hand, most states today are not ready to recognize a general right to health, which would provide grounds for asylum on a global scale. It's also worth recalling that the 1951 Convention itself is also a special law based on persecution and then the 5 elements. Those specifications were designed to reflect the special circumstances of asylum seekers in post-war Europe. The convention, moreover, was limited by geography to Europe and date before 1951, before the limits on geography and date were removed in the 67 protocol. It might be time to think about a climate refugee convention based upon the important jurisprudence of the court, and some standards like the following might be part of that convention. A convention that defines climate refugees deserving as asylum as for a person or persons experiencing adverse climate effects, while not necessarily presenting life-threatening emergencies that were imminent, nonetheless were individuals experiencing an increased threat of a likely loss of life, even if they are not necessarily presently, imminently about to drown, let us say. So going beyond Teotihuaca. They're experiencing threats to family life or indigenous culture, like the ones referenced in the Torres Islands case, so that they cannot practice a dignified life according to the values they hold most deeply and dearly. And those threats are not being adequately addressed by local policy measures, or if not locally adequately addressed, there's an absence of global measures for enhancing resilience that would allow the protection that would permit those individuals to stay at home in their own territory. Failing those things, they have a claim, I would argue, to asylum that could and should be recognized. Let me stop right there. I think I've been within my 10 minutes. But if not, I apologize. I wish I could join you in person. Unfortunately, I cannot, but I'm looking forward to hearing about the rest of the chapters and any comments or questions that come to us, the authors. So thank you very much for your attention. I look forward to the rest of the workshop.
Michael, thank you so much for this lucid presentation and the spelling out of the limits of the 51 Convention vis-a-vis the whole question of climate change and the possibilities of different kinds of migration regimes. But one thing I have always admired about your work also is this forward-looking, constructive, utopian dimension. You with your colleagues came up with a Migration Mobility Convention that was then recommended or in part helped by the United Nations, but here you are now advocating the possibility of a global climate convention when it seems as if it would be difficult to get more than 25 nation states in the same room. But I think that you have to this is good normative Kantian Rawlsian thinking, which I've always admired. Thank you. Now we have Ayten Gündogdu, Associate Professor from Barnard, who takes us back in a very provocative way to contemporary migration regimes and post-colonial practices. Ayten, I'm not quite sure if that's what you're doing, but I think that that was your chapter. So welcome.
Thank you. I hope you can hear me.
Yes.
Good afternoon, everyone. I would also like to begin by thanking Seyla Benhabib and Ayelet Shachar for inviting me to be part of this wonderful volume. I'm really delighted and honored to be part of it, and it is truly also a pleasure to join this event celebrating the volume. I wish I could be there with you in the room, but at least Zoom gives me this virtual opportunity to join this celebration. My chapter in the volume is based on my research for a book manuscript that I'm currently working on, which examines migrant deaths and disappearances in the Euro-Mediterranean region. In the book, I'm interested in two interrelated dimensions of this problem, which directly speak to my contribution to the edited volume. So I'll briefly say those 2 points and then basically discuss the contribution to the volume. While there's often a tendency to cast migrant deaths as tragic accidents, I analyze them as consequences of an institutionally organized and often legally authorized form of state violence. Migrants die and disappear due to restrictive border control policies that aim to deter and terrorize them. And courts refrain from condemning this state violence, and they oftentimes legally authorize it. The second point I want to highlight is that not everyone is equally subject to death and disappearance at the borders, and I attend especially to the disproportionate exposure of racialized migrants to state violence. My chapter in the edited volume develops these points by examining border control policies known as externalization or extraterritorialization, and we have already heard quite a bit about them. These policies include a wide range of practices, including the removal of certain territories from jurisdiction for immigration purposes, as we saw in the case of Australia, interstate agreements to outsource border control to countries of origin and transit, and maritime interdiction of migrants to prevent their entry into territory. Such policies aim to dissolve the connection between territory, jurisdiction, and rights, a connection that is central to modern law. Continuously shifting and manipulating borders, they aim to create what we can call, following Hannah Arendt, a condition of rightlessness. They deny migrants access to territory, personhood before the law, as well as the right to have rights. To briefly sum up my main argument, I propose understanding extraterritorialization and more broadly the juridical regime of border control within the Euro-Mediterranean as a form of lawful lawlessness, which involves strategic manipulation of law itself to create lawless zones, rightless subjects, to recall the title of our edited volume. I developed this argument to question the scholarly tendency to understand policies of extraterritorialization simply as lawlessness. When Australia uses Nauru, for instance, for the offshore processing and detention of asylum seekers, or when Frontex enlists Libyan militias to stop migrants from crossing the Mediterranean to Europe, many analysts consider such acts as striking aberrations from the principles of the rule of law and international human rights norms. But in understanding the problem as one of lawlessness, we risk overlooking how law has come to play a crucial role in border externalization. States mobilize and manipulate law to create forms of lawlessness. And they are manipulating not just state law, but also international human rights law for this purpose. To capture this paradoxical situation, I adopt the term lawful lawlessness, borrowing it from legal scholars Austin Sarat and Nassar Hussain, who introduced it in a different context. Additionally, I argue that lawful lawlessness becomes the norm rather than the exception whenever the law is placed in the service of racial domination. To make this argument, I reconsider the juridical techniques used within the context of border control in light of the juridical techniques introduced by European imperial powers in their colonies. I'll try to unpack that comparison by turning first to the colonial context and then to the migration context. One key element of colonial juridical orders was the manipulation of jurisdiction, particularly by deploying multiple, often conflicting concepts of jurisdiction to deny the colonized equality before the law. In the case of French colonialism, for example, the French state worked with the territorial conception of jurisdiction to assert its sovereignty over the colonial territory, but it also simultaneously marked that territory as an exceptional space where the French laws did not apply. This territorial exceptionality went hand in hand with another notion of jurisdiction based on status that created racialized distinctions between the settlers and the colonized, creating different sets of laws for different racial groups and allocating rights and penalties differently. For purposes of thinking about migration control today, it's also interesting to note that the legal construction of racial difference in the colonies was central to instituting racial segregation and racial immobilization under colonialism. The movement of the colonized was subject to an elaborate system of controls. In certain contexts, for example, the colonized were required to use internal passports to leave their home districts. All these deviations from the modern idea of equality before the law were justified according to colonial powers due to the special conditions of the colony. As a result of this exceptionality, law operated in a more or less permanent emergency in the colonies with the use of continuously changing arbitrary decrees laid down by colonial administrators. This regime of exception was in effect a regime of impunity in which it was extremely difficult to uphold colonial officials accountable for the use of violence against the colonized. While the colonial regime exempted the colonizers from any culpability, it also rendered the natives suspicious in the eyes of the law on the basis of a set of racist assumptions about the innate characteristics of the colonized, including aggressiveness and criminality. The colonial juridical regimes, in short, turned the colonized into rightless entities who could be subject to arbitrary rule and violence with impunity. Let me now briefly turn to contemporary borders to clarify how these elements of lawful lawlessness are reconfigured within a new form of racial rule. My chapter focuses on the Spanish-Moroccan border, the border towns of Ceuta and Melilla. These towns are Spanish enclaves located in the north of Morocco, and they constitute Europe's only land borders with Africa. Between the Spanish and Moroccan sides, there are 3 6-meter-high fences equipped with anti-climbing grids and topped with barbed wire and razor blades. The Spanish-Moroccan border is a site known for pushback operations. And what I mean by that is that when migrants manage to scale the fences and reach the Spanish territory, they are often forced back by the Spanish guardias well to the Moroccan side and handed over to Moroccan border guards. And these pushbacks often turn quite violent, giving rise to many migrant deaths and disappearances. So what are some of the elements of lawful lawlessness that we see within this border regime? In response to that question, we should recall that a signature move of colonial powers was to manipulate different conceptions of jurisdiction to mark their colonies simultaneously as their sovereign possessions and as exceptional spaces where their laws did not apply. We see a similar technique of jurisdictional manipulation in Spain's notion of operational border. Spain asserts sovereignty within Ceuta and Melilla, which would mean that the 3 fences are within its territorial jurisdiction, but it also argues that migrants enter Spanish jurisdiction only after climbing over the 3rd fence and crossing the last line of Spanish security forces. The Spanish notion of operational border is a perfect example of extraterritorialization, which works similarly to the colonial tactic of manipulating jurisdiction in that it aims to create zones of exception where rights and legal protections can be evaded. Not unlike the colonies, manipulation of jurisdiction goes hand in hand with the codification of status distinctions in this regime. As different from colonial rule, status distinctions in border governance are facially race neutral, and yet they have a disproportionate impact on non-white migrants rendered ineligible for mobility. Within the European context, the near default categorization of people from sub-Saharan Africa as illegal migrants is an example of such a racialized status distinction. Violence against these racialized subjects has become routinized in a normalized state of emergency, which has been justified on the basis of assumptions about the peculiar characteristics of borders as spaces of exception, another way in which the colonial context can eliminate the lawful lawlessness of contemporary border regimes. A very short example of this in the case of Spain, the Aliens Act of 2015 established a special regime in Ceuta and Melilla, which means that the Spanish authorities can expel migrants suspected of illegal entry back to Morocco without any inspection of their individual circumstances. This special regime is also a regime of impunity, in the sense that no Spanish official has been held responsible for the pushbacks, even in the case of deaths. While state officials have been exempt from culpability, it is now migrants who are increasingly declared culpable, as their efforts to cross the border collectively are described by Spain as quasi-military attacks that justify the use of anti-riot gear and tactics. This militarized discourse of invasion and enemy is tied to racialized imagery of Africa and Africans within the European immigration context. In the chapter, I discuss in detail how this racialized justification of border control has been increasingly accepted by the European Court of Human Rights. And I use for these purposes 2020 ruling of the European Court, Andi and Anti v. Spain, which in many ways adopted colonial representations of sub-Saharan Africans as inherently violent, aggressive, and hence culpable for even the violence inflicted on them. I'm happy to discuss that case further if there is any interest during the Q&A, but for now, I would like to finish with two important conclusions that I draw in my chapter for the volume. First, we need to rethink contemporary border policies in their racial aspects and in relation to other projects of racial rule, such as colonialism. Second, we also need to critically examine the law's own complicity in maintaining and authorizing the regime of impunity surrounding the racialized governance of borders. That's why I propose to understand this regime as one of lawful lawlessness. I will conclude there, and I really look forward to our conversation. Thank you.
Ayten, thank you so much for this lucid and provocative and very rich piece. Maybe I'm not the only person in the audience in whose mind this phrase, the regime of impunity, is kicking around, because I think certainly what is happening with respect to migrant and asylum rights in our country right now is approaching, or is maybe at the level of a regime of impunity. And I'm thinking also of the detention centers that are now beginning to dot the Texas border, and that it's very clear that migration and refugee issues in particular have become part of the punitive carceral state right now in this country, although the United States is still a signatory to the 51 Refugee Convention, which is part of the Immigration and Nationality Act. But again, the lawful lawlessness. Our next speaker is Frédéric Mégret, whose presence this year at Columbia has been a real joy for myself, for Susanna. He's already participated very actively in our seminar with part of his excellent work on the ties that bind, but his contribution to our volume is on something slightly different, namely maybe that in some of the literature, the refugee is often presented as a kind of object figure, to use a quasi-psychoanalytic term. And I think Fred is trying to bring together the concept of the refugee also as an agent, as a person with initiative. Fred, thank you.
Thank you very much. And I'm delighted to be here. I just want to maybe start off by something in praise of my co-editors, Ayelet. You weren't lying when you said you were rather strict, but I've been in enough, badly managed edited collections that I can see the occasional merit of kind of gentle authoritarianism is how I would describe it. So, the moment is fairly dramatic. I mean, I'm not sure if we could have anticipated in Frankfurt that things would get that bad that quickly. But I do think there's merit to sort of revisiting our thinking at the time in light of the moment. to think with and from the moment, and to think about what the moment portends. I think, there's an element of, as has been mentioned by the previous speakers, of lawlessness. So lawlessness is in fact saturated with law. There's a moment of violation of even those few laws that surface, and then there's a moment of frank revisionism, right, where not even the full lawlessness will do, and in a sense, all gloves are off, and so my sense is that this did not start with the current US administration. To be very clear, it's been preceded by sort of decades of gradual undermining of this regime. But I think there's a sort of qualitative turn that may be happening as we speak. I do note, though, that this is a very old story in many ways, and we're perhaps merely at the point of maximum contradiction between a sort of multi-secular effort by sovereigns to exclusively control territory and the long-term mobility aspirations of peoples. And I think the contradictions are there for all to see. And I don't think a narrative has emerged to understand how we might reconcile the two. So of course the border is central stage. It's where all of these contradictions are magnified and appear the most dramatically. And one thing that we know from border studies is that, am I speaking too close? I'm not sure. Okay. Is that the border has a force of its own. So it's not just the natural outgrowth of sovereignty. It's not really a place. It's not really a law, although it relies on law. It's constantly regenerated through technology, and in a sense epitomizes the power of the state, so which is on some level a power of life or death, or even a friend-enemy designation power, but also more literally the power to decide who gets to come in and who needs to get out. And so that obviously reinforces a tremendous sense of privilege and discrimination. A lot of the work in the literature on borders has emphasized how the border is less and less physical. It's more diffused through digitalization, externalization, internalization. But what I was interested in doing in this chapter is looking at the extent to which the border is internalized, as it were, in the minds and even bodies of those who have to cross it, and that, in a sense, is its most powerful legacy. The fact that the border sort of builds the people that it needs. It builds people in its image, and that makes it extremely hard to challenge. We're all, in a sense, slaves to the border because we have no choice but to get through it. I mean, we all know this. I was, if you're going through a border, this is the moment to behave. There's a certain way of being in that moment when you have that little chat with the immigration officer. For most of us, this involves nothing more than, more dramatic than these little rites of passage and showing one's passport. But of course, for others, it requires something much more radical in the form of a sort of reshaping of the self to get through. So what I emphasize in the book is sort of a mixture of docility and agency to get through the border, and that is the goal. You have to play the game of the border, but it also creates spaces for strategy. So one of the things we've been reminded is, is this sort of fundamental dichotomy and sort of the international law of mobility between the migrant on the one hand and the refugee on the other. And each are, in a sense, sort of playing their cards as they cross the border, trying to maximize their ability to get through. So for the migrant, this may, and sometimes a bit of a taboo to mention this, but this may involve claiming that one is a refugee in order to get through, on the understanding that there is actually a path, if you're, however narrow it may be, if you're a refugee, that doesn't exist if you're a plain migrant. So every migrant, in a sense, wants to be a refugee or to be considered a refugee, and that one of the negative effects of this whole regime must be on the long term a kind of culture of bad faith, right? And I don't say this in a sort of a conservative sense, but these the refugees are in fact all migrants who are abusing the system. But I think that is just one of the implications of that dichotomy existing. Now, what I'm interested in the chapter is the opposite danger, and that's the danger that the refugee, let's assume that hypothetically the refugee is indeed a refugee, has to constantly distinguish themselves from the migrant to prove a kind of asylum bona fide. And so in the process, they're sort of constantly repressing the extent to which they're also migrants. And so the intuition here is, one is not just I mean, these are categories of a mind, right? One is not just a refugee or just a migrant. Certainly a lot of refugees are people who at one point decide, okay, we need to go. Like, it's no longer safe. We need to leave Syria overnight. But immediately after that, you start asking yourself questions about, well, where are we going to resettle? How far do we go? What kind of risks are we willing to take? Decisions and strategies were much more typical of the trajectory of migrants, right? The problem is that the kind of the iron rule of being a refugee and being identified as such means that this is unsayable, right? You cannot say that refugees are also migrants because that could weaken their case for asylum. And that then creates these sort of weird situations where, I mean, generally the response, and states are sort of waiting because they need excuses to not comply with the Geneva Convention, is to say, well, if you're only a refugee, and you can only be a refugee, just seek asylum in the first safe port of call. And so why do you need to travel all the way to the UK if you could have sought asylum in Bulgaria or, much sooner? So that then sort of breeds this very weird, sort of almost Darwinian culture where, people go take extreme risks to get to the place where they actually want to seek asylum. And sort of emerge there and sort of constantly trying to beat the system, but in ways that I think just can't be accounted for by the international refugee law regime. So this is something that is constantly repressed. Now, the truth is that we have every reason to think that asylum seekers are also constantly making choices that are normatively significant, important, and I think that any normative theory of this sort of mobility should be able to express. They have obvious preferences, life preferences. They want to settle in a place where they have a chance of getting work. They want to settle in a place where they have relatives. They want to settle in a place where there's, members of their community, where they can speak their language, etc. And so, that is why, I mean, people will take considerable risks to cross the channel on dinghies, even though, frankly, they're, fleeing France and before that, cross the whole of Germany. And so therefore, in terms of their pure protection need from Assad or whoever they're fleeing, and as far as the Refugee Convention is concerned, they would have clearly been able to access full protection, the minute they crossed these countries. And so in the chapter, I try to say, there are strong normative reasons why we would want to take seriously the fact that refugees don't just want to get asylum, they want to get asylum in a particular place. And that is not asking a lot. And we should have, an international law that is capable of catering to that. So, I suggest for example, that often they may have historical or post-colonial claims to obtain asylum in a country that is closely associated with the cause that led them to flee in the first place. So an Afghan asylum seeker would have a strong claim as against the US or an Iraqi asylum seeker, given the usually disruptive impact of US military actions there. Rwandan or an Algerian might have similar claims against Belgium or Algeria. So that just leads me maybe to a couple of concluding thoughts. I think there's a real question in the moment. Is this the moment to be conservative and to try and defend what's left of a sort of international liberal status quo as it emerged after the Second World War? Should we be prudent or should we be bold? And is this actually a crisis that we should take advantage of, not to try and simply reassert the status quo, but to show maybe emphatically the extent to which, the reason why we are here in the first place is because the status quo has not historically delivered.
Thank you. Thank you, Fred. Thank you. It's a very audacious contribution because so much of the discourse is based on distinguishing the political refugee from the economic migrant, right? The whole framework, not in this country, but particularly in Europe. And so by pointing out that also the refugee is also more like the migrant than one would like to think because of initiative, etc. I mean, the conservative would say, yes, we know that they're gaming the system. But you're saying it's not that easy. We have to think about it. And we have to think about the question of refugee agency. I mean, the very difficult issue that this raises also is whether refugee law is just about protection or if there is more to asylum, more than protection. Also the possibility of settlement eventually, the possibility of building a life, etc. Something that one doesn't like, that every asylee is a potential migrant, right? I mean, we sort of want to push these categories aside. And last but not least, Susanna Mancini, thank you so much for leading us into the discussion, and we look forward to your comments.
Yeah. Okay, thank you. So thank you, actually, Seyla and Ayelet, for having me here today. It really is an honor and a pleasure to comment on a book which has been absolutely eye-opening for me, because it's not just because it is comparative, because it is interdisciplinary, but what this book does is to systematize all of these issues that we see popping up here and there, appearing, but they're not, as Ayelet was saying in the beginning, these are not just, facts that happen. It is a pattern, right? It is a pattern, and migration policies and border enforcement tactics have reshaped legal and political landscapes, and states, private entities, international organizations have been manipulating territory, jurisdiction, legal frameworks to control migration, resulting in excluding the most vulnerable segments of the world population from the rights associated both to sovereignty as well as to the human rights framework. So to discuss some of the themes of this volume, I will rely on an example that you actually mentioned in your introduction, but which you could know because it had actually a number of surprisingly and unexpected consequences, right? And I think it's ultimately an example which will offer a glimpse of hope. For those of you who are not familiar with this, in 2023, Italy signed an agreement with Albania, a protocol, right, envisaging extraterritorial migration and asylum management, including detention and asylum processing in Albania. This entails the setting up of detention centers, where some third country nationals, both rescued in the Mediterranean as well as already in Italy, will be taken to Albania for the processing of their asylum applications and eventually to expel them if the applications aren't successful. So very unfortunately and very disappointingly, a first assessment by the European Commission concluded that this deal is outside of European Union law. It's not in breach of European law, not substantively, because clearly it is in breach of every possible like constitutional principle of the European Charter, but because European law is not applicable outside of the European Union territory. In the second place, this agreement is not technically an international treaty. Therefore, it is exempted from all the checks and balances, the legal certainty, the proper forms of international agreement. So it has prevented public scrutiny. It has prevented democratic accountability on the sides of the two parliaments involved, right? Which is very convenient, of course. So it is democratically very problematic, as I think in the book very well puts forward Svenja Alhaus, because border politics become increasingly obscure, not only for non-citizens, but also for citizens. And this reduces the space for contestation, really turning the shifting border into a fundamental democratic issue. Moreover, the arrangement between Italy and Albania would follow a selective disembarkation model. So those deemed vulnerable would go to Italy, while those deemed not vulnerable would would be taken to Albania. Of course, this is not just unfair, it's also unlawful, because it clearly is going to result in differential treatment on the ground of a very fast and superficial assessment of vulnerability, which has nothing to do with identifying the specific needs of the actual people that should be processed. So here I very much agree with Frédéric's observation in his chapter, where he holds that the shifting border produces, I like the way you say it, particular kinds of subjecthood and subjectivities, which relate to reductive and simplistic claims about the conditions in the country once left. Finally, obviously, the memorandum or protocol between Italy and Albania does not specify which courts are competent to handle the procedures for migrants and asylum seekers detained in Albania, which I don't need to specify what right it actually affects, right? The right to a remedy and judicial protection. So in brief, this agreement does everything that the title of your book so brilliantly captures. It creates a lawless zone and rightless subjects. The reason why I wanted to share this case with you, however, is not just that I am worried, as we were saying jokingly yesterday with Seyla, your book will give bad ideas to the wrong people, because it seems as if you have a recipe for disaster, right? For governments that are receptive to this kind of schemes. But I wanted to tell you what happened afterwards, because there have been many legal challenges regarding the implementation of this deal. First, judges in the immigration court in Rome rejected the detention orders issued by the police for migrants being transferred to Albania. And then asylum denials were subsequently challenged all over Europe by lower courts. So the courts determined that the countries from which the migrants were coming, and mainly Pakistan and Egypt, were not considered safe. In fact, I like the way some of these courts worded the problem of determining safety. Well, they say, how can a state be considered safe when there are social groups for which it does not meet the substantial conditions for such a designation? And this highlights the problem that also you put forward in relation to the notion of safe country, which ends up by being a chimera, because in the end, no country is objectively safe for everybody, right? So in the end, the Italian judges referred the matter to the European Court of Justice, questioning whether the Italian government also list of safe countries, right, as well as everything else, complies with European Union law, and whether it is consistent with the broader human rights framework and legal obligations that European Union member states are bound by, take into account that Albania is outside of the European Union, right? So we are expecting a ruling in April and keeping our fingers crossed. Of course, the government, the populist right-wing government, was highly irritated by this saga. Many attacks took place, including by Elon Musk, who relentlessly tweeted that the Italian immigration judges need to go. This is how he put it. However, this did not obviously intimidate the Italian judges because, as of last week, the Cassation Court of Italy sentenced the Italian government to pay compensation to a group of illegal migrants that, mostly from Eritrea, that were transported on an overcrowded boat because the government did not allow them to disembark, depriving them of their personal freedom. I just want to read how the Prime Minister, Giorgia Meloni, reacted to this decision. Due to this decision, the government will need to pay compensations with the money of honest Italian citizens who pay taxes to people who try to enter Italy illegally, violating the law of the Italian state, which of course resonates a lot with what Ayten's analysis, right, on racialization and historical continuities with colonial governments is. And it also made me think of the analysis of Eric Hobsbawm in Age of Empires, right, when he says that breaking up the world in all these formal and informal colonies that serves to foster social cohesion within European nation states, especially when you have discontented masses, right? Because it fosters ideas of superiority and domination, as he puts it, over a world of dark skin. So, placing these Italian stories of resistance within your call to propose alternative frameworks for understanding rights and obligations in a transnational context and calling for a more inclusive and flexible approach to human rights, right, that transcends state boundaries and recognizes the rights of individuals, regardless of status and nationality, I think that we can learn the two important things. One is that we do have to strengthen the rule of law and be very vigilant because, and by the rule of law, I mean specifically the preservation of judicial independence. Ayelet, you were first talking about, there's pushbacks from certain states. Sometimes you don't need the state. You need judges because courts are fundamental. And Ayten said before that courts don't protect. Sometimes they do protect. So strengthening judicial independence is important because human rights are countercultural. They are counter-majoritarian. They are revolutionary. And you need strong, independent judges to uphold them. In the second place, of course, you need to strengthening the coordination between domestic law and international and supranational law against challenges that come from great supporters of state sovereignty. And we've seen this, in the context of the European Union with Poland and Hungary constantly challenging the authority of European Union law. This is also in the light of the fact that the post-Westphalian dynamics that emerge in your book, which is really a description of the undoing of Westphalia with no coherent project to replace it, however, right? It is a scenario in which we do have to challenge the legitimacy of state sovereignty, a sovereignty that, as Eva Maria Schäferle puts in her chapter, is increasingly problematic because territorial rights increasingly fail to fulfill their original function, which is to resolve potential conflicts, right, by separating the spheres of responsibility of states. But also the legitimacy of states is closely tied to the protection of the fundamental human rights of the people under their jurisdiction. And if a state fails in this regard, we know this from humanitarian intervention, etc., sovereignty is weakened from an international law perspective. So just to conclude, well, Seyla knows that I am a Kelsenian at heart. So I just wanted to propose that perhaps we should look back at some of the international law theory put forward by Kelsen, because Kelsen did associate the primacy of international, I would add, European Union and human rights law more generally, with a pacifist, anti-imperialistic ideology intended to oppose the logic of power of modern individualistic state. It was, in a way, also a political program, not just a pure doctrine of law, advocating an evolution of the international legal community from what he calls a primitive condition, right, imposed by the dogma of state sovereignty, to a universal organization of mankind, right? And within this organization, within this framework, morality, politics, and economics should converge somehow and be integrated under the aegis of law. And once the system of the world state has absorbed, right, all these normative systems, the law, as Kelsen puts it, the law will become the organization of mankind, right? And accordingly, all of a piece with the supreme ethical idea. Thank you so much.
Wonderful, Susanna, to end with Kelsen, you know, it's and it's just of course.
Yeah.
But now there is so much to say. You've been all listening. There is a reception, by the way, so there is food and a drink, but maybe we should now open it to some questions and comments. And yes, please.
Well, I can start, maybe break the ice. Hi, I'm Eleonora Bottini. I'm a professor in France, but I'm also Italian and also been following what Susanna was mentioning. And I just had two reaction, one from Italy and one from France. The one from Italy is, of course, that the particular quote that Susanna used to signal what the government of Italy thinks of what justice and judges are doing, never mentioned the fact that the reparations attributed to those migrants were actually due to an action of the Minister of the Interior, who kept them outside the port. And that, so of course, it is not them who motivated the use of honest Italians' money, but an actual minister who was still in the government at the moment, and his illegal action that actually made honest Italian people spend their money in reparations. So that's particularly striking. I think I didn't know this quote. So I don't want to say thank you because I'm not feeling better after I heard it. But I also had a remark / question about something that Michael Doyle had said about climate refugees. I was interested by this French judgment of the appeals court of Bordeaux, sort of taking into account the health issues that pollution in Bangladesh presented as a risk to this particular migrant. And I did not have the case in mind. I went and have a look, and I was interested to see that the Council of State, so the Supreme Administrative Court, reversed that judgment. And so effectively sending the Bangladeshi migrant back to Bangladesh in an interesting way that you can see in the conclusion of the public rapporteur of the affair, who seemed particularly mad or say disturbed by the press coverage of the Bordeaux court judgment, that since in the press it was presented as the first case of climate refugee in France, or somebody that was accepted as a climate refugee. And so the public rapporteur, who is part of the Council of State, said there are many mistakes in the law by newspapers, which, I mean, it's not particularly surprising. They're not necessarily lawyers, because this has nothing to do with climate refugees. It has to do with a different aspect of French law, which is migration or permit to stay in the country for health reasons. And so it is misleading to present it as a climate refugee case. Therefore, the Supreme Court should reverse, sort of, and that's my saying, not to open the door to future claims of similar nature, just signaling that France does not have any rule about climate refugees, and we should certainly not start that in court, right? It is not for judges to start something new like that. It might be the legislator, might be the government, who knows, but it's not for judges to do that. So I thought it was interesting, and I was wondering about the potential backlash of going out and from courts, but also our scholarly discourse from going outside what already exists in terms of refuge. So maybe it goes also to what Fred was saying about whether to stay conservative and trying to maintain what's already there that is being violated, or being bolder and more imaginative. And I think the French case showed that sometimes imagination and judicial imagination can be dangerous, because I'm not sure the Supreme Court would have reversed were it not for this reference in the Court of Appeal decision to atmospheric pollution, and that opened up this backlash and this going back on a principle that is in fact widely accepted in French law, that is, for health reasons, people might be allowed to remain in the territory. Thank you, by the way, for all this.
I'd be happy to respond if this is the right spot for it. Hello?
Yeah, go ahead. Do you hear us,
Yeah,
Michael? Go ahead.
Please.
Yeah, thank you. I appreciate the comment very much. I saw the reversal. The reason why I went to the case is that the administrative court in Bordeaux was tackling a fundamental issue and setting forth standards, building upon French health law, as well as the problem of asylum, in ways that, even though reversed by the French courts, are worthy of emulation, that it was the quality of the standards that they were setting. It was the case that tackled the problem that the individual was not facing an imminent loss of life, that is the standards developed in Teotihuacan, but the likely threat to his life that would come from him being deported to Bangladesh. So it was the quality of the reasoning and the addressing of the problem that I thought was interesting and worth, from a normative point of view, being adopted in a wider convention that addresses the real problem of persons experiencing that kind of a threat from climate change that can't be encompassed within the Teotihuacan standards of immediate harm. So the fact that it was reversed is unfortunate, needless to say, from the standpoint within French law. But for the quality of the argument and the interest it bears for dealing with a serious problem that's not covered with Teotihuacan, that was what made it interesting to me.
Stuart Eldon, geographer, critical theorist.
Thank you. Territorial sovereignty has at least two elements in it, and that they're often, I think, confused, which is that within its boundaries, a state is sovereign, and that those boundaries are fixed. And they have two very different histories, one of which is much more recent than the other. And I'm struck that it's 100 years since the Locarno treaties this year, 1925, that were trying to fix the boundaries in Western Europe, particularly of France and of Belgium with Germany. And we've heard things about how climate change can change boundaries, or that territory may disappear. We've heard things about how states might try to change their boundaries for these legal reasons of jurisdiction, of saying that an area is outside of the jurisdiction. What hasn't come through, particularly in the conversation today, is about how since the Second World War, there's been this attempt to say that states cannot change boundaries of other states by force. They can't grab a piece of territory. They can't promote a secessionist movement in a territory. That doesn't mean it hasn't been breached, but that has been the assumption in international law since the end of the Second World War. So in a sense, putting into practice the idea of Locarno. But what I think we're seeing at the moment, and I think the idea that there may be an imposition of a territorial settlement for Ukraine, some of the changes that are happening in the wider Middle East at the moment, are we seeing an unraveling of that part of international law? And that seems to me to be something that could really exacerbate the kind of issues that it seems that this book is talking about. And that, is it a conservative wish to hold to the old post-war settlement with all of its problems. But even decolonization was managed within the existing boundaries. That was what the African Unity Declaration was about. We recognize that these boundaries are colonial impositions, but we will decolonize within those boundaries with all those problems. It just seems to me that there's something very big happening at the moment, potentially changing at the moment within that, that connects to so many of the themes that you've been talking about.
Stuart, first of all, thank you. Lovely to meet you. Of course, and I'm sure others have read your work, so it's a pleasure to actually meet in person or across the, we will meet in person individually later on. You know, this is something we did not cover in the book. Obviously, I think in your line of thought, and I'll actually leave it, Fred, if you might want to say something about the pure international law, because I think it's a technical question to some extent, but on our conception, I think it is partly, as I mentioned, our motivation. When I wrote The Shifting Border, I was really trying to just create this third category, saying it's not just either fixed or this borderless world or something else which is going on and has a real dark undercurrent to it. And to some extent, I think that is what you're describing now, this potential unraveling of territory in the sense of a bulwark against another country taking involuntarily, basically, either capturing it, engaging in war, what have you, right? All of these issues are really beyond our focus because we were looking at the mobility of individuals across borders and more so how borders actually cross individuals, right? So it's the mobility of borders that to some extent conceptually allows states to extend their long arm way beyond where the territory ends. But I do think that I get your intuition, right? It's something about that notion of territoriality and the stability that at least it has granted, if you want to think about that unity of peoplehood, territory, a legitimate government, right? The kind of traditional definition of sovereignty and statehood that we have. So if that's the point that you're alluding to, I think it might, in that sense, share some of the intuitions that we have had in the book, but we really, none of our chapters have looked specifically at that question. And also, if I can just say something, just Susanna, I so appreciated because we didn't sort of respond to that. I thought that was just such a nice elucidation. And also I appreciated the fact that you referred to Eva Maria and to Svenja, because both of them are online with us and have really had chapters that were talking about the democratic aspect. And I really appreciated the fact that you brought that in towards the end. But I also want to suggest that the story that you told us about the Italy-Albania agreement, I think it has precisely these kinds of internal contradictions that we were trying to capture in the book. That is the Commission initially saying, it's not Europe. That's exactly a kind of shifting border move, right? The implication is individuals who actually reached Europe because they reached Italy are now moved outside of Italy, but the Commission can say it's Albania, it's not us. All right. And later on, also just the fact that it's not an international treaty. Therefore, it's not subject to the standard procedures and protections. This I want to suggest actually to connect to some of the issues that we know have happened also on this continent, right? The ACAs, the Asylum Cooperation Agreements, which were done under the initial Trump administration, later on rescinded by the Biden administration. But these were agreements which I remember I was just searching the text. You couldn't even see the text of a government's exercise of authority. So clearly the fact that these are not, it's not unintentional that they're done outside of the standard democratic or even just the standard way of writing agreements, even if they're not, in the EU, you would have to go through the European Parliament. In some other countries, even if it's a foreign relations matter, still the basic accountability of actually seeing the draft or the final product would be very, very significant. So I think that element is alarming, and we're seeing governments do this continuously. If you think about some of the rules, which even under the Biden administration, you remember initially there was the third country transit ban, which was under the initial Trump administration, the idea that if you pass through a territory, and that actually, Fred, speaks to your idea, right? If you the safe third country, or they were called third countries. They were not even labeled as safe. The U.S. government didn't even bother to say that they would be safe because they couldn't uphold, say, El Salvador necessarily as safe for migrants. They just said you pass through a third country. The fact you did not seek asylum there bars you when you actually reach the U.S. You're sort of pushed back to that earlier moment in time, and they did not even put the safety requirement, which is striking. And then you had the circumvention of again the kind of the Biden rule, which was a little bit more modified, but the same logic that if you pass through another country, you should have actually the fact that you did not seek asylum there puts you, the asylum seeker, at a disadvantage. I think, Ayten, that connects very much nicely to your analysis, right? So something happens here that we forget all of these questions of the history, we forget all the question of violence. It's just a very technical argument. You have passed through a country, you did not seek asylum there. Why are you coming to us, the richer country, the safer country, the country that you actually is your destination country? So to some extent, not just erasing agency, but also really in being punitive, not just to the migrant, but also to these countries that now all of a sudden have to carry that burden that people actually seek to reach the US. So I think these are all troubling developments. They're occurring. And I do think that what they all share is not necessarily, they're not always lawless zones or really even leading to people to be rightless, but this weakening of the kind of links that we have thought about territory and human rights, I think definitely are present in all of these examples.
We've got maybe two final things. Monica, I wanted to say something too, and then we can turn back to the panel and maybe Fred or.
Okay, thanks, Monica Hakimi. So I'll just piggyback on something that you said, because I agree that the territorial boundary, the security of territorial boundaries in international law are very much, and the insistence in international law that territory may not be taken by force, I think is being eroded, and is being eroded very dramatically, not just in places like Ukraine and Israel-Palestine, but also in the South China Sea, in the Himalayas, Ethiopia, Somalia, Venezuela, Guyana, the Democratic Republic of the Congo. These are all places in which they're less dramatic, but nevertheless serious. And I think they very much affect a lot of the questions about migration, because this norm that prohibits the taking of territory by force is actually a norm that is rooted to some extent, is rooted in the idea that each state ought to have authority in its own territory, is rooted in the idea that we ought to prevent cross-border violence, but is also rooted in ideas about self-determination and the idea that a people within a given territory ought to be the sort of like collective that advances its own vision of the good. And of course, international law has never really satisfied perfectly, anywhere near perfectly, that idea of self-determination. But if you take that idea seriously, I do think it requires us to sort of appreciate the tensions that mass migration creates for democratic polities that try to define themselves by certain territories and organize politically. And I will say, just I personally I think I have not adequately accounted for the pressures on a democratic polity that defines itself as such, that migration brings. And I don't think it necessarily has to bring, but as a practical matter, in many societies around the world, we have seen it bring this sort of like backlash, and this insistence that says like, no, we are a political community as we define ourselves and you are not part of it. And so the real question, I think, and the question that I personally have been struggling with quite a bit in our current moment, is how to think about that very real social phenomenon in the world that cuts against, I think, so many of our shared, in this room, normative commitments to ensuring basic protections for in the service of humanity when people are fleeing really awful conditions. And so I'm just curious to know a little bit how you think about that dynamic, the dynamic between the two.
I have some thoughts on it. Maybe this is going to be conversing when I come to your seminar. I think that, of course, in terms of a juridical understanding, there is a definition of the people of the territory. But the actual people is never just simply composed of the juridically entitled citizen. There is always the other, be it the historical, be it the geographic, be it the generational others. So it's a way of, saying that I think that I share your democratic intuitions, and I share the point about boundaries and borders, and there's a very dangerous moment. But we should also not hypothesize the people as if it always excludes the other who does not have the full juridical status. And I'm going to venture that in today's world, there is hardly any nation state that does not have its others in one way or another. So yes, mass migration can pose challenges, but the question is there a way to democratically represent the voice of the other who may not be a full member? I mean, this is what I worry about, I work on in democratic theory. There are a couple of essays in this volume, and the question of voice is not that insuperable. In other words, you can find various levels in which migrants, the voice of those who are not full citizens can be articulated. In part, this is happening. There are city elections, municipal elections, regional elections, right? This is something that I've called disaggregation of citizenship rights, right? Even if you are not a full-fledged citizen, you know, you have rights, let's say, in parents-teachers councils. In many big, in London, for example, if I'm not mistaken, depending upon your Commonwealth status, etc., you have rights to vote for the municipality. And also in New York, this question about rights of permanent residence, for example, came up. So I appreciate the democracy question, but what I'm saying is that democratic voice and representation is not something that needs to pit the democratic people against the migrant and the other.
Can I make one last comment? I'll make it really quick. I mean, one of the fascinating issues I see here are the different ways in which are kind of like different models of derogation from these obligations in a way. And I mean, I see a few. One of them is a kind of a legal mechanism, right? And you see this not only in the immigration context, you see in the war on terror, but kind of like trying to legalize a process, like use the law to, you keep in place the treaty, but you interpret differently, right? As you were talking about in Australia, for instance. Another way is to use the state of exception, which seems to be what Trump is using predominantly right now, right? Everything is a state of emergency. So that is what allows, questions of transportation to Guantanamo or the deportations, right? So it's used. And then, of course, there's some just simple kind of transformations and derogations from the treaties themselves, right? So there are different ways in which it can be done that these states are kind of rescinding their obligations. And I think that we need to think about what are the consequences of using those different paths, is an interesting question as well, I think. Yeah.
Maybe it's time to invite you all to some food and drink. We don't seem to have more questions. So has been, oh, I'm sorry, Trump, I didn't see your hand up, but.
I don't want to stand. That's a very dangerous place to be. That's a very dangerous border.
But we could hear your question. It's not that drastic. It's right around.
Okay. I'll keep it brief. Borders are, of course, about distinctions and about the struggles we fight over those distinctions, territorial borders, cultural borders, conceptual ones. And I think that one of where this struggle is particularly salient is the struggle between the powers of the state, the executive and judiciary. The Italian case is particularly in point. And I would like to know from the panel very quickly, what do you think about the increasing use of AI in migration control? Because I think that the use of AI in migration control has two effects. One is to even more objectify, reify the migrant, transforming them into just bundle of data entry points, and therefore affecting the human dignity, understood as the capacity of advancing claims against authority that they might have. And secondly, I'm afraid that AI is giving a kind of bazooka to the executive, because even if we might imagine a control over administrative procedures after their application, it will be very, very difficult from judges to basically contrast the judgment of machines that are supposed allegedly to be precise and efficient, even, hoping that they would not be completely marred by racial biases.
Okay, I'm going to close on a dialectical note because this fits with our panel, right? Or not, just I want to take your question. It's a great one. And we know that there's more use of AI. And frankly, we don't actually have yet so much data on it because not so many countries have used it. But I think the concern about biases, racialization, all of that is, we know from other instances, is a very, very real concern. And I agree with you that either putting the human in the loop or suggesting, even if you go to an immigration official, sometimes it's even just the initial screening at the border. There are fascinating studies of observer participants who are then going to the immigration official and saying, how did you respond to the reject? And very few of them actually overrode the reject. And the question was why? And they said, we don't even know what the algorithm is. Maybe there was something so bad that we just didn't know. Therefore, I agree with you. It's a totally real danger. However, I just want to bring in one thing, which I think might surprise you, but you recall that, again, under the previous administration, there was the notion of the CBP1 app, right? So basically it was admission for, and you had to file for a time slot to have to basically file your claim for asylum before you reach the border. And I, among others, really criticized that because we were worried about all the biases that this entails. However, I do want to suggest that in some way it was using the power of technology potentially to protect a migrant or an asylum seeker and say, yes, even from afar, you can actually at least seek that appointment, which if you pass the basic threshold, you will actually get a full hearing. And I'm quite concerned and in some way not surprised that one of the first things that this new administration did was they barred it because they really saw it as a way to empower migrants. So I want to suggest there might be, all of these tools could lead to greater oppression. But I want to believe, and I think that was the spirit of our project altogether, to say perhaps internally there's such contradictions that could ideally be used, hopefully, by either human agency, by some new theories, I agree with you, Barnard, by really being very careful about delineating what tools are being used, but hopefully just finding a way not to just say it's all foreclosed, we're all just doomed, which might indeed be the current moment, but to at least try and say, we've always known that even under very repressive circumstances, either theories have been changed, our conception of sovereignty, our conception of humanhood or personhood, citizenship, all of these are potentially up for grabs, and hopefully not just for the restrictive story. Potentially we might have something else that might emerge from it, but totally at the level of aspiration at this moment in time.
We have one more urgent, you've been there from the beginning. Please introduce yourself, and maybe the answer would come over food and drink, but it's good to hear. Good to hear the question.
Absolutely. And I'm really going to make just a very short comment. I'm Isabella Trombet. I'm a visiting assistant professor at NYU. Great fan of all of you in the room. But two comments at this point. One, just piggybacking off of the CBP1 app and of your comment. And funny enough, there have been reports of the app not recognizing certain pictures because of the ethnicity. So definitely a lot of criticalities there. But the remarks that I just wanted to make was that I particularly appreciated, I read the book as it came out, and I particularly appreciated that there was a space for the sea part of it, where I really think, I'm from Italy and I work about, the sea, and I work on maritime borders, and I think that that's really going to be the space where international law, hopefully, will have to make the leap from states just looking for loopholes to exclude the unwanted, to proactively creating, hopefully, new spaces for migrants to cross border. And I'm going to close it there and not hold from food.
Thank you. That's such a wonderful remark, because one of the, I think, really original papers, they all are very good, is the paper by Itamar Mountain called Territoriality from the Sea.
Yes,
right?
exactly. That's the one I was
Which
referring
is,
to.
yeah,
That's a
thank
great
you.
piece.
Yeah. Well, upon that note, let's go to the next room, and thank you all.
Seyla, thank you for organizing this particular event.